Hi, welcome to the DC Bar Pro Bono Center. Today we're going to be talking about insurance and risk management assessments for nonprofit organizations. I'm Scott Levitt. I'm here with my colleagues Kevin Glandon and Laura Locke, and we are all attorneys in Covington and Burling's insurance practice group. Today we're going to talk about insurance for nonprofit organizations and try to demystify the topic of insurance a bit. It may not be something that you deal with every day, and we're going to try to give you some of the basics so you're armed as you look at policies and think about the risks that your organization faces and what to do in the event of an incident. We're going to talk about first how to read the policy, then we're going to talk about several different types of insurance, including commercial general liability insurance, which may be the most common type of insurance that your organization may have. So let's talk about the basics. What is insurance? Insurance is a creature of contract, just as a lease or contract to buy a car. A lot of the same rules will apply to all types of contracts, regardless of whether it involves insurance. An insurance policy protects against certain types of risk in return for payment of a premium by the policyholder to the insurer. And different policies protect against different risks. So what should you think about when you're buying insurance? First, what are the nonprofit's assets? What risk does the nonprofit face? Who may be liable and who is covered? So let's dig down into those questions. What are the nonprofit's assets? Typically, a nonprofit's biggest asset is its people, board members, employees, volunteers, donors, clients, and the public. And depending on the nonprofit, you may have a substantial amount of property. You could have a building that you either own or rent, equipment that you use in your business, and also intellectual property. You have income that comes in, whether they are sales from t-shirts or grants from government organizations or donations from people who support your mission. And then finally, you have goodwill. You have the reputation, you have the ability to raise funds and secure volunteers, and you should not minimize the value of goodwill. It can be hard to value, but it's certainly important to any nonprofit organization. So what risk does the nonprofit face? Probably most problematic would be injury to people. Somebody trips and falls on your premises or at an event. Somebody has a work injury, whether they're driving to an event or on site doing something in furtherance of the nonprofit's mission, or there could be some sort of negligent care in the services that you are providing to people. You may have property damage. There could be a fire, storm, a car accident. Unfortunately, you could be the victim of criminal activity. There could be theft, embezzlement, and fraud. Some of that theft could be done through cyber rather than a physical incident, and that could take the form of a data breach or hacking. And finally, you could have some sort of compliance failure where you are alleged to have violated legal or regulatory requirements and the government comes after you. There are two main types of insurance. The first type is first-party insurance, and that protects against losses that you as a policyholder sustain. An example is you own a building, there's a storm and the building gets damaged. The other main type of insurance is third party, or also called liability insurance. And this type of insurance protects against claims that are made by third parties against the organization. For instance, somebody comes to one of your events, they trip over a box that somebody left in the middle of the floor, and they sue you. In that instance, your liability insurance would respond. So let's talk now about how to read a policy.
Hi, my name is Laura Locke, and I'm an associate in Covington's litigation and insurance practice groups, and I'm going to walk through how to read a policy with you. Insurance policies can be very long, sometimes hundreds of pages long, and are often not written very clearly. So, do you really need to read the entire policy? If you want to understand your coverage, then yes, you do really need to read the entire policy. An insurance policy may grant you coverage in the insuring agreement, take it away through an exclusion dozens of pages later, then give it back, but only partially, in an endorsement attached to the policy. If you only read part of the policy, you won't have a full understanding of what's covered and what's not. Our goal here is not to short circuit your review, but to give you the tools you need to review effectively and efficiently. This slide gives you an overview of the principal parts of an insurance policy. There is the declarations page, the form or body of the policy, which contains the definitions, insurance agreement, exclusions, conditions, limits, sublimits, and deductibles. There may also be a set of endorsements, which are additional forms attached to the policy. I will explain each of the parts in a bit more detail in the slides that follow. So common policy features. The declaration page is at the front of your policy. It is usually the first page of the policy. It summarizes some key information vital to the policy. It's like the vital statistics of the insurance policy. It generally lists the policyholder's name and address, the policy period, the types of coverages provided, coverage limits, premiums the policyholder must pay to maintain the policy. It also lists deductibles, retentions, or retained limits. These terms refer to the amount the policyholder must pay on a claim before the insurance policy kicks in and provides coverage. We'll talk more about those later. Although the declarations page looks like a summary of the policy, the endorsements at the end of the policy may change the terms of the policy from what's listed on the declarations page, so it's important to review the entire policy and not simply rely on the information in the declarations page. Definitions. Within the body of the insurance policy, you'll find a definitions section. The definitions section is key to understanding the policy. Policies define common words like the word loss or property damage and give them a special meaning. The definition may narrow the meaning of a term in a way that narrows your coverage, so it is important to read the definitions section carefully. Terms that are not defined in the definitions section are simply given their general, common, ordinary meaning. When you're reviewing the rest of the policy, defined words may be identified with bold print, quotation marks, or they might be capitalized. Some policies, however, do not make clear which words are defined, so it is important to review the entire definition section and keep it handy as you review the rest of the policy. Insuring agreements. Insuring agreements are also within the body of the policy. An insuring agreement is a statement of what the policy covers. The policy may call the insuring agreements a coverage, and there may be more than one coverage section setting forth different types of coverage. For instance, in commercial general liability policies that cover different types of losses, you may see a section titled Coverage A, Bodily Injury and Property Damage Coverage, and then a separate section titled Coverage B, Personal and Advertising Injury Coverage. The insuring agreement is modified by the conditions, exclusions, and endorsements in the rest of the policy. There are typically a lot of defined terms in the insuring agreement, so it needs to be read side by side with the definition section to be properly understood. Exclusions. Policies also typically contain an exclusion section. The exclusion section sets forth the losses not covered by the policy. For instance, most property damage policies exclude damage caused by flood or earthquakes. You usually need to purchase separate insurance and pay a higher premium if you want coverage for those losses. The exclusion section can also contain exceptions to a particular exclusion. So it might say, for instance, we will cover damage to your airplane, except under these particular, we will not cover damage to your airplane, except under these particular circumstances A through C. This makes it clear that circumstances A through C are covered under the policy. Exclusions are not only found in the exclusion section. They could also appear in the endorsements, which are tacked on at the end of the policy. They may also appear in the body of the policy, but outside of the exclusion section. So it is important to read the policy carefully and look for any exclusions throughout the policy. Conditions. Conditions are requirements the policy holder must meet in order to obtain coverage. Like with exclusions, you should look for a conditions section or requirements section, but still review the whole policy for conditions not listed in the conditions section. Giving notice is an example of a common condition. Many policies provide that the policyholder must give notice of a claim within 30 days or within a reasonable time period after learning of the loss. If you do not give timely notice, you may waive your right to coverage. Another example of a condition is a requirement that the policyholder cooperate with the insurer's investigation, meaning the policyholder has to provide information about what happened and the nature of the loss or damage when the insurer asks for it. The policy might also require that you obtain the insurer's consent before hiring a lawyer or settling a claim. Review the policy and identify all conditions your organization must meet in order to qualify for coverage, and keep a list handy so that when an accident occurs or when someone sends your organization a demand letter and you think they may sue, you know what steps your organization needs to take to maintain its claim for coverage. Limits, sublimits, and deductibles. Limits are the maximum amount of money an insurance policy will pay out for a covered loss. Policies may provide a per claim or per occurrence limit, which is the most the policy will pay on each claim or each occurrence that leads to a loss. The policy may also list an aggregate limit, which is the most the policy will pay out for all accidents or all claims that occur during the policy period. Your policy may also contain sublimits, which further limit the amount your policy will pay out for a specific type of loss. For instance, a property damage policy may have a limit of $1 million per claim, but a mold sublimit of $50,000. That means you don't get to tap the full $1 million for mold damage. You are capped at $50,000. Sublimits may cap coverage for a single type of incident, a type of damage like mold, or a particular category of property. A deductible is the initial amount of loss not covered by the policy that the policyholder must absorb. You're probably familiar with the concept of a deductible from your health insurance or car insurance. For example, your car insurance might have a $1,000 deductible, which means that if you were at fault in a car accident with damage of $5,000, you're responsible for paying the first $1,000 out of pocket before the insurance kicks in and begins providing coverage. You can negotiate the amount of your deductible with the insurance company, but typically the lower the deductible, the higher the annual or monthly premium. Endorsements. Endorsements are policy forms attached to your insurance policy that modify coverage. So why don't insurers simply modify the body of the policy? Well, insurance companies typically issue insurance using standardized coverage forms. So the body of your policy is typically a standardized form. If the policyholder does not want to pay for a particular type of coverage or wants additional coverage not provided in the standardized form, rather than modifying the standardized form, the insurers tack on additional standardized endorsement forms to add or remove coverage from the coverage granted in the body of the policy. The endorsement may be added after the policy is issued and may have language at the top of the endorsement indicating when the endorsement becomes effective. You can see that on the example in this slide. Endorsements can also modify aspects of the policy, including the scope of coverage, limits of coverage, or change who qualifies as an insured under the policy. Since endorsements can seriously impact the coverage provided by a policy, it is important to read them carefully. With that primer, let's turn towards a discussion of particular types of policies you may have. I will turn it over to Kevin to discuss commercial general liability insurance.
Thank you, Laura. My name is Kevin Glennon, and for the next several slides, we'll be taking those general principles and applying them to specific types of insurance coverage. These next sections are intended to be reviewed together with your DC Bar Pro Bono Center Insurance and Risk Management Assessment Tool. So these slides refer to questions on that assessment tool, and they should help you understand what you're looking for and the implications of what you find. Commercial general liability insurance, as mentioned, is third-party insurance. It protects you and your organization against claims that your actions caused harm to someone else. These policies typically provide two types of protections at a high level: indemnity and defense. Indemnity is the protection where the insurer will pay for legal liability incurred by the insured, such as your organization, through a lawsuit or other legal proceeding. This might be a judgment that is handed down. It could be a settlement that you enter into with the claiming party. Typically, this will be for bodily injury, property damage, or personal injury. The words personal injury may, depending on your policy, refer to things like defamation and other torts as opposed to bodily injury, but you'll have to read the policy for sure. Policies also typically cover defense. This means that the insurer is often required to hire and pay an attorney to defend you. This is a very important protection, especially for nonprofits. The duty to defend, in other words, pay defense costs and control your defense, is typically broader than the duty to indemnify, in other words, pay liability costs. That's important because a lot of what organizations need protection for is the legal defense. But it also means that just because the lawyer defends you does not necessarily mean that when there is a judgment or a settlement that it will be covered. So additional advice in this space is important. The policy may give the insurer the right to consent to selection of defense counsel or even to control the defense. Under CGL policies, defense costs are usually what's known as outside limits, meaning they do not erode your limits of coverage. However, it is important to confirm. So turning to the assessment tool. Question 1, and I will be talking about certain key questions for the next several slides, but I will not return to questions that we've already discussed. So we'll focus on the key new questions or questions where there has been an important qualifying point to raise. So question 1 on the CGL checklist, is your policy a claims-made policy or an occurrence policy? Claims made means it is triggered by a claim. The policy will pay on claims made or made and reported to the insurer during the policy period or some other specified period as specified in the policy. We have an example on the slide of a type of insuring agreement that shows you that this is a claims made policy. Another type of policy is an occurrence-based policy. This is triggered by an occurrence, a term of art that means that it pays claims related to something that happens, the loss event, during the term of the policy, regardless of when the occurrence is presented to the insurer. And here again, we have an example of some language where you can see an occurrence coverage. Tips here would be looking for that insuring agreement portion of the policy to determine whether it's claims made or occurrence based. The terms claim and occurrence are often defined also in the definitions section. Question 2, what dollar limits does the policy specify per occurrence, in the aggregate, per claim, or for deductibles? The per occurrence or per claim limit, this is the maximum amount of liability the policy will cover for any specific claim or occurrence. So say, for example, a person sues the organization. There may be a per claim limit associated with that. If there is a slip and fall accident, that may be an occurrence. And if somebody sues, there may be a per event limit. However, in addition to per claim and occurrence limits, there are almost always aggregate limits. This is the maximum amount of liability that the policy will cover. The payment of claims reduces the aggregate limit. So if you hit that limit, the insurance company may discontinue to provide any support under that policy, including discontinuation of defense costs, but that will depend. The deductible, as mentioned by Laura, is the initial amount of loss not covered by the policy. You may see language about self-insured retentions, which function slightly differently, but in any event relates to amounts that you will need to pay. Tip here, limits are commonly found in a limits of liability section in the declarations portion of the policy. Question 3, what sublimits apply? Well, if we have a limit, what is a sublimit? A sublimit exists to reduce coverage for a particular type of event or a particular situation. Fortunately, however, they are typically of limited scope. So where a sublimit applies, your limit is going to be lower. On the other hand, you're probably only going to see a sublimit related to a particular type of incident, damage, or property. Tip here is that the dollar amount of any sublimit is typically shown in the declarations portion of the policy. However, make sure to read the policy to determine whether all or only part of a particular loss is subject to a sublimit. Question 4, does the policy extend to legal defense? We've talked about the duty to defend. Where this exists, and you can see language here, typically something along the lines of, we will have the right and duty to defend the insured against any, in this case, suit seeking certain damages. The duty to defend means the insurer is obligated to assist the insured in mounting a legal defense against claims. And this is broader than the duty to indemnify, meaning that even if somebody makes a claim against you that is false, fraudulent, groundless, or ultimately unsuccessful, arguably, the insurer should provide you a defense. Now, typically, the insurer has the right to consent to the selection of defense counsel or possibly even to control the defense. Now, if your policy does not contain a duty to defend, it may contain reimbursement language. This is where the insurer will reimburse the organization for the legal fees and expenses it incurs. And again, we have some language here showing how that type of clause might appear in your policy. Again, for CGL insurance, usually defense costs are often outside the limits. And your policy may not be as clear as this, but here's some language. These payments will not reduce the limits of insurance. That's quite clear. Some policies are less clear, but you should read carefully for that or ask your broker or insurance company to clarify. Question 5, what locations are covered? This is important, especially for an organization that operates or has missions or other activities in multiple jurisdictions. Make sure that your policy covers you in every state in which your organization operates. You may find that a policy was put into place a few years ago covering when your organization was smaller or at a different scope of activity, and for cost purposes, the scope is limited to 2 or 3 states. But now you're bigger. But if your policy isn't bigger, you may have some significant exposure, and that should be fixed, either through the next renewal or immediately through an endorsement that changes the nature and scope of your coverage territory. Question 6, who are the named insureds under the policy? Are employees included as named insureds under your CGL policy? What about volunteers? If anyone associated with your organization is not listed as a named insured or in a section about that, your policy may not cover claims made directly against that person. The declaration portions of the policy may explain who is covered in the named insured section, but this section may only list the entity that purchased the policy, so you should also be on the lookout for a definition of insured or a who is uninsured section. Question 7, what are the key exclusions? These are the gaps. It's important to know where the gaps are and mind them. If an exclusion applies, the policy may not cover the liability, even if it would otherwise be covered. For example, and this is a common misunderstanding here, the expected or intended exclusion, which will exist in almost every policy, provides that there is no coverage for liability resulting from intentional acts or where the injury is expected. However, this does not necessarily mean what people think it does. For example, over the long term, you could expect that slip and fall accidents might occur. Does that mean that you expect slip and fall accidents and therefore it's not covered? No. This does not apply to general non-specific expectation of liability over the course of some policy period. That's why people buy insurance. Also, intended usually means intended from the perspective of the insured. So if an employee does something that causes someone harm, it is often the case that the organization itself, which is an insured, did not intend for that to happen, and therefore this exclusion often should not apply. Other examples of common exclusions that may exist in a CGL policy include pollution, war and terrorism, cyber, mold and fungus, asbestos. Take a look in your policy for the word exclusion, and if you find an exclusion that is problematic for you, I would suggest buying an endorsement or looking into an additional policy. Question 8, how must notice be provided? In other words, how much do you tell the insurer that something happened and what do you have to tell them? Here, timeliness is important. If the notice is late, the claim may be denied. Prompt notice of a claim or loss is typically required, but the specific requirements vary. A policy may say notice must be provided immediately, or as soon as reasonably practicable, or within a certain specific number of days. Also, you should pay attention to what triggers notice. Must notice be provided regarding circumstances that could give rise to a claim? For example, you heard that somebody was injured, but nobody said anything yet. Perhaps that would be a circumstance that would give rise to a notice, and you should let the insurers know, because if you don't, the insurers may later say, well, you knew about this but didn't tell us, and therefore you have failed to satisfy the notice conditions. The content of the notice requirement may change depending on the policy. You may have to take action to protect property from further loss. You may have to prepare some additional information about what happened. You may have to make a property where the slip and fall occurred available for inspection. You may have to provide any copies of any written letters or suits to the insurer. Now let's talk about D&O insurance, directors and officers insurance. This is vital for a nonprofit. This protects your directors and officers, your board members, makes sure that people will want to run your organization and want to help out. An organization's board of directors and officers, D&Os, sometimes employees, are usually protected for liability under this type of insurance. Or this would be liability arising from service based on their role as a director or officer. It may also cover organizational liability. This is a funny type of insurance that has sides, and there's often 3 sides to directors and officers insurance. Side A is the D&O's liability that is not indemnified by the organization. Side B covers the organization's payment of indemnification to the directors and officers. And side C would protect the liability of the organization itself. Big D&O risks these days include failure to implement proper cyber protections. You'll hear later about cyber insurance, and financial management and use of donor funds. Those are types of risks that D&O insurance might help protect your D&Os against. Question 1, D&O insurance is typically claims made. That means it covers claims made during the policy period. Questions 2 and 3, policies typically include an aggregate limit on all claims under the policy, as well as limits on individual claims. So here's a case where paying attention to the aggregate is really important. If you have a claim against the organization and there's a specific per individual claim, per individual limit, but then there's an aggregate limit against all claims, the question is your aggregate large enough to actually protect your organization? Otherwise, you might have different people searching for their own share of the limits. Question 4, will the policy cover a director's defense costs? Take a look. Are employment-related claims against directors covered, or is that something you'll have to find protection for elsewhere? Consider also, under question 7, purchasing an extended reporting period coverage to avoid gaps in expiring policies. Okay, switching topics to property insurance. Well, what is that? This is first-party insurance. It covers your organization's losses, typically your building, your vehicles, your business, personal property, computers, etc. In terms of the types of loss, it is very important to take a look and find out if your property policy is an all-risk policy or a named peril policy. An all-risk policy covers all perils unless specifically excluded. A named peril policy, on the other hand, covers only those perils named in the policy, which is, for example, a fire, a windstorm, hail. When you're looking at the types of loss that could occur following a property insurance event, you can have both physical losses and what are called time element losses or economic losses. As to the physical losses, does your policy cover replacement costs or actual cash value? How does your policy value a loss? Will you receive enough to rebuild or repurchase, or just compensation for the diminished value of the asset? As to time element losses, your policies may cover the insured for income loss due to a covered event or for extra costs of emergency action or continuing the business during a rebuild. Looking at the questions, question 1, a peril is the cause of loss. Make sure to review all named perils or to check whether it is an all risk policy and to look for any exclusions. Question 2, policies typically provide different treatment of different types of property. For example, computer equipment and data storage media may be excluded or treated differently. Tip here would be that coverage for causes of loss commonly excluded from property policies, such as flooding or cyber events, may be available for purchase through a standalone policy or add-on. Even if your policy covers some of these losses to a degree, and you may find a certain degree of protection for your computers and other computer equipment, a lot of the risk there is being transferred into cyber policies, and you'll want to make sure that you have the appropriate level of coverage, and that may mean purchasing a separate policy. Make sure to reevaluate the risks associated with climate change, including risks of flood, wildfire, and hurricanes. Where are your businesses, where are your locations at? Are they in a flood zone? There are FEMA maps that could help you find that out, but the risks seem to be higher than the flood maps sometimes show. And we've seen that in the news. Same thing with fires, same thing with hurricanes. And depending on where you're located in the country, you may have seen this already in terms of significantly increasing rates for renewals. Question 3, consider the organization's financial situation and how it would handle a major loss. Actual cash value, for example, is unlikely to be sufficient to replace the damaged property. It costs more to buy a replacement cost policy, but if your building is destroyed and it would cost, let's say $2 million to rebuild it now, but your actual cash value policy only covers the diminished value, which is, let's just say for the moment, $500,000, and your policy then says, well, you're completely destroyed. It's going to cost you $2 million to rebuild, but this policy you bought only provides $500,000. Suddenly you have a gaping hole in your budget. Question 4, coinsurance, do you have it? In the context of property insurance, typically this relates to a requirement that the property be insured for at least a specified percentage of the value of the property measured at the time of the loss. In other words, the insurance company is wanting to know, are you actually paying them enough for the current value of your property? And if your policy has not been reviewed in several years, it's possible that the value of your property is different than is listed in the policy. And although that may lead to temporary lower rates, it also may mean that in the event of a catastrophic loss, you have a penalty to pay based on a formula listed in the policy. Question 5, in addition to covering damage to property, property insurance may also cover other expenses and losses that relate to the loss of property. For example, employee dishonesty typically covers theft. This could be a section in your policy, or it could be an entirely different policy. Law and ordinance coverage. This is important. It typically covers the increased cost of complying with building codes in place at the time of the loss. So if your building was built a long time ago and it's significantly damaged and it has to be brought up to code, ADA, etc., it may cost a lot of money to make those changes. You need to know whether your policy is going to cover that or whether that's going to fall to you. Boiler and machinery coverage will typically cover equipment. It may cover interruption associated with the loss or breakdown of equipment. You'll want to make sure you understand what type of equipment could break down and affect your nonprofit. If your policy does not cover the risks, as always, you may be able to purchase additional endorsements to your policy or entirely separate policies. Moving on to employment practices liability. This is another common risk. Like everything else, you definitely ought to have this coverage. This protects the organization against certain claims by workers or applicants, people who may not even work for you yet, that their legal rights have been violated. Claims may take many forms, including discrimination, sexual harassment, wrongful termination, or retaliation. Policies may also cover breach of employment contract, defamation, failure to promote, negligent evaluations, workplace torts. Sometimes these policies may include arbitration provisions. So whenever you have a bunch of people working together or working with management, there's a possibility that someone may feel that they have been wronged, and this is the type of policy that you'll want to protect yourself against that circumstance. Question 1. Employment practices liability may be provided for in a separate policy or policy section, or may be covered claim under a general liability provision. As to the separate policy or policy section, that's relatively easy to determine. Either you have a separate policy, and usually would have something related to employment practices in the title, or that may be the name of a section in your larger, business policy. But if you don't have that, you would at least want to check your CGL policy to see whether or not an employment practices liability claim may be covered under your CGL. This will take careful reading, and you may want to talk to your broker or insurance company and then get a second opinion. Question 4, for employment liability policies, defense costs are often included in the limits of insurance. This means that the payment of attorney's fees will decrease the total amount of coverage you have. Here's some example language that shows this. And as many things happen in the context of insurance policies, you have to read through the definitions. Here we have each payment we make for damages or defense expense reduces the limit of insurance. Well, what is defense expense? Defense expense is separately defined to mean many things, including, for example, attorney's fees. So this is important because in many cases for employment practices liability, defense costs exceed the damages. Question 7, pay close attention to exclusions as they may materially impact the extent of coverage for employment practices liability. For example, the following may be excluded: punitive damages, intentional acts, we talked about that one briefly, statutory benefits such as ERISA, COBRA, OSHA issues, workers' comp, which we'll talk about, ADA, contractual liability, and criminal, fraudulent, or malicious acts. Question 8, carefully review the notice requirements and the definition of a claim, including whether the claim must be written or could be oral. Treat employee complaints as claims and provide notice. Now let's talk about professional liability or E&O coverage, errors and omissions. This is the type of insurance that you'll want if your organization employs lawyers, medical professionals, mental health counselors, therapists, social workers, architects, accountants, or other professionals who provide professional services. Any of these types of persons will have their own insurance for providing their special services. And if you employ them to provide a benefit to the public, you will need professional liability or insurance. This is typically not covered by standard CGL insurance, as that type of insurance generally requires bodily injury or property damage. As to question 1 on your form, what types of professional services does your organization offer? Does your policy provide coverage if one of your professionals makes a mistake? Think about it. Question 7. What types of errors or omissions are covered by your policy? This is a careful language reading exercise. For example, does it cover breach of duty, like if an employee attorney mismanages client funds or breaches client confidences? The lawyers have duties to their clients. If they breach them, you may be liable. Does your policy cover that? Another example would be, and here's a comparison, negligent act, error, or omission versus negligent act, negligent error, negligent omission. Arguably, the former would cover negligent acts plus errors or omissions, whether negligent or not, whereas the latter would cover negligent acts, but it would only cover errors and omissions that result from negligence. So you have to read the policies very closely. So with that, I will now turn it over to my colleague Laura to talk about workers' comp.
Thanks, Kevin. So turning it over to workers' comp. Workers' compensation or workers' comp is typically required by state law. Here in DC, for example, workers' comp insurance is required if the employer has 1 or more employees. Workers' comp insurance covers the medical expenses and a portion of lost wages of employees who suffer on-the-job injuries. Coverage is provided regardless of whether the employee is at fault. It's important that your organization have workers' comp insurance, not only because it is required by state law, but also because it minimizes your risk of dealing with an expensive lawsuit from an injured employee. With workers' comp coverage, the employee is offered compensation for their injuries and lost wages in exchange for a mandatory relinquishment of their right to sue the employer for negligence. Workers' comp policies may also provide related coverage, such as employment practices liability insurance, which can cover claims by employees that the employer failed to provide a safe work environment. In assessing your coverage first, and this goes along with the first question of the assessment tool, check to make sure that the policy covers employees in every state in which your nonprofit's employees are located. You also need to check that your coverage in these states is consistent with the state law requirements, which means figuring out the workers' comp insurance law in each state where you have employees. The Department of Labor's website has a link to the state workers' comp websites for each state, and this should be a helpful starting point. Second, check whether your organization has a process in place for collecting certificates of insurance from subcontractors and subgrantees. You want to make sure that workers' comp is available to the employees of your subcontractors and subgrantees so that they are covered and your nonprofit is not exposed to liability if they are injured while working on your property or with your organization. Turning next to business auto insurance. Business auto insurance covers liability and may also cover physical damage protection for vehicles that are used for the nonprofit's business. The liability portion of the policy covers the cost of damages to other vehicles or property and personal injuries caused by accidents when the driver of your organization's vehicle is at fault. The physical damage portion of the policy covers repair of physical damage to your organization's own vehicle. Your organization should get business auto insurance if your organization uses a vehicle to run errands, pick up and deliver goods, carry tools, transport clients, or for any other aspect of your nonprofit's business. Business auto insurance can be tailored to the needs of your organization. So, for example, if you have a vehicle that you use primarily for business purposes, you can secure business auto insurance to cover any employees and volunteers who drive that vehicle for business purposes. Let's say, on the other hand, the nonprofit itself does not own a vehicle, but you have a bunch of employees who use their personal vehicles for the nonprofit's business. Your employees' personal auto insurance policies may still cover them in the event that they cause an accident while driving for business purposes. But if it's a major accident, their personal auto coverage may not fully cover the damages, and the injured parties may seek to collect damages from your business. You can seek business auto insurance that covers any of your organization's employees or volunteers when they drive any vehicle on business. Now let's go over a few points you should check when assessing your business auto coverage. Again, each of the questions appear on the assessment tool as well. Question 3, check who is listed as a named insured on the business auto policy and think about who at your organization drives vehicles on business. If you have volunteers and employees driving on business, you may want to make sure they are treated as an insured under the policy so that the policy will provide coverage in the event that they cause an accident while driving on business. Question 4. You should also check how broad your coverage is and whether it meets the needs of your nonprofit given your vehicle use. If your employees and volunteers drive their personal vehicles on business, or if your organization uses rental cars, you will want to secure non-owned and hired business auto coverage. Additionally, you should make sure that your policy includes uninsured or underinsured motorist coverage. All organization vehicles should have this coverage, and it may be required by state law. Also, check to see that your policy covers medical costs, regardless of who is at fault in the accident. Medical payments insurance is required by some states, and you will want to make sure that your policy includes this coverage given the potential costs of medical payments in the event of a major accident. Finally, question 5 of the assessment addresses background checks. Your policy may exclude from coverage drivers who have committed certain moving violations, and your policy might require your nonprofit to perform background checks on the driving records of all persons authorized to drive your organization's vehicles. If the policy requires background checks, you should make sure that the background checks are updated regularly, since this may be a condition to coverage, and you may not be covered if an accident occurs and it turns out that the employee at fault had committed certain prior moving violations that excluded the employee from coverage under the policy. Now I will turn it over to Scott to discuss cyber risk coverage.
We live in a brave new world where almost every organization, every person faces some sort of cyber risk. It's impossible to avoid in modern circumstances. So what does cyber risk cover? It covers a liability, which means a third-party claim arising from a data or a security breach, often involving sensitive or private information. This can take place in the form of a hack or a ransomware attack. It can be started if an employee or a volunteer accidentally clicks on an email that has a link to malware, or it could be a targeted intrusion into your system or a denial of service. So when considering whether to buy cyber risk insurance, you need to consider your organization's risks. And I'll note that not every nonprofit does purchase cyber insurance, but we are seeing more and more nonprofit organizations buy cyber risk policies. So considering your organization's risks, what type of information does the organization hold? Is it holding medical information, sensitive financial information of people, or other information that would be particularly harmful if it was ever accessed or disclosed? Essentially, any organization that stores and maintains customer, client, or patient information should consider cyber insurance. So question one is assessing your coverage for data breaches, hacking, malware, and other cyber risks, because those risks are often excluded from CGL or general liability policies. Separate cyber policies are available. The market for cyber policies is continuing to evolve. Insurers come into the cyber insurance space, they leave it, and they come out with new products all the time. So the products that insurers are offering in the cyberspace have to be carefully evaluated. Commercial general liability policies may cover lawsuits alleging violation of privacy under the policy's coverage for personal injury. They may cover emotional distress or mental harm, or loss of use of property such as credit cards. But these general liability policies more and more have cyber exclusions. But the first step is to see whether you may actually have some cyber related coverage under your CGL policy, and that may be enough. But often it isn't due to the prevalence of cyber exclusions. Property insurance may cover damage to your hardware or data or lost profits in the event of a cyber incident. Again, property insurance policies often have cyber insurance, so you should check to see whether there may be any cyber coverage at all under your property policy. D&O policies generally cover suits alleging failure to prevent or disclose a cyber incident, but those policies vary as to whether they cover employees and whether there has to be a securities claim alleged, but there may be coverage nevertheless under D&O policies. So the takeaway is that exclusions vary among cyber policies and other policies, so you must read them closely. I'm going to talk now about excess insurance. So what is excess insurance? Excess insurance applies above a primary policy limits or a certain retained limits, and this gives you extra coverage in the event that the cost to defend a claim or settle a claim exceeds the limits of your primary policy. So question one in the excess insurance section is looking into your excess policies, in that they come in different forms and they can vary significantly, and that affects the scope of coverage and the complexity of pursuing a claim under those policies. An umbrella policy typically provides a broad based liability coverage on top of certain existing primary policies. Those are typically auto liability, employer's liability, and general liability. As with commercial general liability policies, an umbrella policy may provide broad-based protection against a wide variety of risks, but it also contains a variety of exclusions that may be important. Sometimes the terms and conditions may differ from the primary policy. Sometimes the umbrella can provide broader coverage than the primary policy, but by the same token, sometimes they restrict coverage. Related to umbrella is another type of excess policy, and that's what is generally called follow form. Those type of policies provide excess coverage over one or more specified primary policies, and they typically say that they follow the terms and conditions of the primary policies, though they add some additional wording that may affect the scope of coverage. Question 6 on the evaluation is, which policies are primary to your umbrella or follow form excess policies? If you have a primary policy that is not listed on your excess policy, the excess policy may not provide coverage if that primary policy is exhausted. So it's very important to look at your excess policies and figure out what is listed and what is not listed. So you want to identify the limits of the excess policy. In the event of a loss, you want to make sure to track the exhaustion of those limits. And bear in mind that it may be necessary to provide notice of a claim or loss to the excess insured right away at the same time you're providing notice to the primary insurer, even if the underlyings have not been exhausted, and even if you think the underlying limits may never be exhausted. It's always good to provide notice early so that it can't be raised as a defense later on down the road if your insurer were to argue that notice was untimely. So finally, I'm going to talk about some other policies. Property policies often cover business interruption, but occasionally we do see separate standalone business interruption policies. And what those policies cover is a loss of revenue or profits arising from a covered incident. And under property policies, that's usually a physical incident, such as a storm, or perhaps a government shutting down an area for a civil riot or something. We had that in DC several years ago during the pandemic. You may have a service interruption policy, and again, that may be included in your property program, and that covers things such as a loss of utilities, loss of internet services, which causes you to lose revenue. Fidelity bonds are specialized insurance policies that generally cover wrongful acts by employees or contractors, such as an employee stealing cash out of a lockbox. But it certainly can involve more complicated scenarios than that. There are special event policies, particularly for off-site events. These sometimes include liquor liability coverage. You should check to see if you are having a special event, whether your existing policy will cover that, or if not, you would want to talk to your broker to see whether a special event policy may be worthwhile. We see certain organizations procure child or sexual abuse policies. Sometimes that's, and oftentimes that's included within a general liability, but it's a special add-on policy. It's not generally offered to all insureds. Those type of policies or coverage can be crucial for any nonprofit dealing with children, and it's often excluded from general liability policies unless that coverage is specifically requested, and it often comes with an additional premium. There are specialized policies for equipment, though those coverages are also often provided under property policies. Same thing with electronic data processing. You may have equipment that does that for you, and that is often covered under your property policy. But if it's not, there are standalone policies that cover that. So what should you be looking at with regard to all these other policies, including the specialized standalone policies or the policies that we've been talking about throughout this presentation. For every additional policy, you need to identify what is the risk covered. Is it a risk of fire? Is it a risk of theft, malpractice, or something else? Particularly important when you review the policy is learning who is covered by the policy. For instance, is only the organization covered, or does it include employees? Also, does it include a volunteer? That's often particularly important for a nonprofit organization, because you want to encourage people to volunteer. And if there's a incident and one of your volunteers is sued and there's no coverage, that is not going to reflect well on the organization, and it may cause you various other headaches. So when you're looking at these other policies, you want to consider what loss is covered. Is it a personal injury, such as a bodily injury, somebody falling down, somebody getting hit by a baseball at a charity baseball game, or property damage? You have an event in a space and somebody breaks something in the bathroom, and the host of the space sues you for that damage. You want to understand how must the loss occur. Could it be through a negligent action of an employee, a contractor, a donor, somebody attending your event, or does it need to be some sort of natural external force like a flood? Where does the policy apply? Some policies provide coverage only for losses or claims arising out of the United States, or sometimes even within a particular jurisdiction. So you want to know more about that, particularly if you have operations that are occurring outside of your home location. Quickly, liability policies generally fall into two categories: a claims made or an occurrence basis. Claims made means that the claim has to be asserted during the policy period and usually also reported during the policy period or within a specified number of days after the policy. For example, 90 days is fairly typical. Or liability policies can be written on an occurrence basis, which means that the underlying incident or damage has to occur during the policy period. And you could have an occurrence policy that is implicated because of a loss, say that happened, or an incident that happened in 5 years ago, but that claim from that occurrence only is asserted during the current policy period. You want to look at what type of coverage is provided. There is indemnity-only coverage, and also there are policies that provide a duty to defend. And the main difference between indemnity and a duty to defend policy is that with a duty to defend, the insurer pays the attorneys on behalf of the policyholder, so the policyholder doesn't have to spend money out of its own pocket. With an indemnity policy, by contrast, the policyholder pays for the expenses, then goes to the insurer and says, pay me back. You want to understand what are the policy's financial terms. What are deductibles? What are self-insured or retentions or underlying limits? So these are all financial terms that must be satisfied before the policy actually pays real money. You want to look at what's called an aggregate limit. That is a total overarching limit that specifies the maximum amount that the insurer will ever pay on the policy. You also want to look at what are sublimits, and what we see frequently is that insurers offer all of these terrific coverage as bells and whistles to your policy, but then they stick it with a really small sublimit. For instance, we see sublimits on what's called social engineering fraud, which is a scenario where somebody pretends to be, say, the organization's president and calls up an employee and asks them to wire $20,000 to an account. And it turns out that the account is controlled by a fraudster. There can be coverage for that type of scenario, but generally insurers don't like it. And They want to limit their exposures, so they stick a very small sub-limit on that type of coverage. Finally, you want to look at what are the notice requirements. Some insurance policies require notice as soon as practicable. Some have more lax timeline requirements for giving notice, but generally we recommend that notice of an incident or a claim be provided as soon as possible, so that there can be no dispute down the road with the insurer whether you provided notice in accordance with policy terms. So that's all of our presentation. We thank you for listening and viewing the presentation. If you have any questions, you can reach out to the Covington team on this presentation at dcbarinsurance@cove.com. Thank you and have a great day.